The concept of, quote, valid votes, unquote, is well known to the legislative framework governing the electoral process. The concept has a particular meaning in that context. The phrase appears several times in the Representation of the People Act, including in Section 96 of that Act. That section, Section 96, calls on the Chief Election Officer to calculate the total number of valid votes of electors which have been cast for each list of candidates. Validity in this context means, and could only mean, those votes that on their face are valid. The determination of such validity is a transparent exercise that weeds out of the process, for example, spoiled or rejected ballots. This is an exercise conducted in the presence of the duly appointed candidates and counting agents of contesting parties. It is after such invalid votes are weeded out that the remaining valid votes count towards the determination of not only the members of the National Assembly, but incidentally as well, the various listed presidential candidates. If the integrity of a ballot or the manner in which a vote was procured is questioned beyond this transparent validation exercise, say because of some fundamental irregularity, such as those alleged by Mr. Harmon, then that would be a matter that must be pursued through Article 163 after the elections have been concluded and the victors declared. At the point in the electoral process where Article 177(2)(b) is reached, there is no further need to reference valid votes because, subject to Article 163, which is triggered by election petition after the election, the relevant validation process has already been completed. By the unnecessary insertion into Article 177(2)(b) of the word valid, the Court of Appeal impliedly invited the CEO to engage unilaterally in a further and unlawful validation exercise that trespassed on the exclusive jurisdiction of the High Court established by Article 163. It was inconsistent with the constitutional framework for the CEO or GECOM to disenfranchise tens of thousands of electors in a seemingly non-transparent and arbitrary manner without the due processes established in Article 163 and the Validation Act. For all these reasons, the court adjudged that the provisions of Article 177(4) were not triggered by Ms. David's application to the Court of Appeal. Since the Court of Appeal had no jurisdiction to hear the application brought by her, the finality clause in Article 177(2)(b), in 177(4), was inoperable, and under the laws of Guyana, this court had jurisdiction to hear and determine the application by Messrs. Ali and Jagdeo and to set aside the decision of the Court of Appeal. This court was also entitled and required to declare invalid the report issued by the CEO, which was based on the decision of the Court of Appeal. It follows that the appeal of Mrs. Ali and Jagdeo succeeds. The court was addressed with great passion by some counsel appearing before us to make a raft of consequential orders relating to the elections. In this regard, it is important to bear in mind that this case is essentially about jurisdiction, about our jurisdiction, about the jurisdiction of the Court of Appeal, and even implications for the High Court's exclusive jurisdiction under Article 163 and other articles of the Constitution. The court reminded itself that its jurisdiction had been invoked for the sole purpose of determining whether the Court of Appeal lacked jurisdiction to entertain David's application and to make the orders that it made. Once we decided that the Court of Appeal's order was made without jurisdiction and should therefore be set aside, there was nothing left upon which this court would possess jurisdiction to make any further consequential orders. To accept counsel's suggestion and proceed down that path would have been to engage in an exercise not dissimilar from the one embraced by the Court of Appeal majority and which we have issued. It is for GECOM to ensure that the CEO submits a report in accordance with its directive of 16 June in order to proceed along the path directed by the laws of Guyana. As Guyana's final court, the court stated that it could not, however, in all the circumstances, pretend to be oblivious to events that have transpired in that country since December 2018. Indeed, the court had to pronounce on some of those events. It has been 4 months since the elections were held, and the country has been without a parliament for well over 1 year. No one in Guyana would consider this to be a satisfactory state of affairs. We express the fervent hope that there would quickly be a peaceable restoration of normalcy.